Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we continue to look at the Delphi case. There's been a lot of news in this case. If you're not familiar, then maybe you could read this quick recap over here that I've put up for you, or check out the link in the description box. There's a playlist there for you. I've even made a case file for you, which is all the chronological press conferences and media briefings, and then the announcement, of course, that they arrested a suspect, Richard M. Allen, who was living right there in Delphi. So if you remember correctly, if you've been following this case with me, on October 19th of 2023, there was a hearing in Allen County in Indiana, and Judge Gull came out from the chambers and told everyone that Richard Allen's attorneys had withdrawn. So she said that Andrew Baldwin filed an oral motion to withdraw, but that Bradley Rozzi would be filing a written motion to withdraw in a couple of days.
Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rozzi will be submitting a written motion to withdraw, I'm assuming within the next couple of days.
So since then, I've been looking for this written motion to withdraw, and I just couldn't find it. And then yesterday, a lot of documents came out, and he is not going down without a fight. One might say, if you ever commit a crime, you would want an attorney like this. Like, this guy is fighting so hard for his client, and he is facing all the, I don't know what to call it. To me, there's a lot of suspicious stuff that goes on in Delphi, and he's just bravely charging ahead against all of it and wanting to expose all of it. Of course, everyone can interpret this differently, but it seems to me that he's like, okay, well, if this is what you're going to do, Judge, here's what I'm going to do, which I find very interesting. So we're going to dive into 5 of these latest documents and see what has been said and what the response was. So I'm going to read them in chronological order based on the dates that are on the top right-hand corner and the time. You can see this was from the 25th of October, 2023 at 7:51 p.m. This says State of Indiana versus Richard M. Allen. Verified notice of continuing representation. Comes now, Attorney Bradley A. Rozzi, counsel for Richard M. Allen, and in support of his verified notice of continuing representation, now swears and affirms as follows. On November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Counsel has engaged in the continuous representation of the defendant Allen since that date and time. On October 12th of 2023, the court communicated with Prosecutor McClelland, Attorney Rozzi, and Attorney Baldwin, at which time the court ordered Attorneys Rozzi and Baldwin to cease work on Mr. Allen's case until the parties were set to appear in court on October 19th of 2023. The chilling effect of the court's emailed order was to essentially strip defendant Allen of his Sixth Amendment right to representation and essentially disarmed attorneys Rozzi, Baldwin, and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court. In an October 17th, 2023 email, Attorney Rozzi requested a conference to determine what we, the court, the prosecutor, and defense counsel, are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on the record in open court. In response, the court ordered both the defense and prosecutor to appear in chambers at 12:30 p.m. on October 19th. On October 19th of 2023, attorneys Rozzi and Baldwin appeared at the Allen County Courthouse in advance of the 2 p.m. hearing. This was prompted by attorney Rozzi requesting that the parties communicate in advance of the scheduled hearing. Attorneys Rozzi and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the in-chamber conference, which took place in 2 parts. The court first conducted business as it related to several pending motions by communicating with the parties and issuing rulings on said motions. The court then read a prepared statement to attorneys Rozzi and Baldwin, identifying various issues throughout the case through which attorneys Rozzi and Baldwin exercised gross negligence in carrying out their responsibilities as counsel for defendant Allen. The court then suggested that attorneys Rozzi and Baldwin engage in a discussion outside of the chambers regarding the allegations. Attorneys Rozzi and Baldwin asked for clarification, at which time the court communicated to attorneys Rozzi and Baldwin that there were 2 distinct options. 1. Either voluntarily withdraw their appearances and exit the courthouse in advance of the hearing, or 2. Participate in the 2 p.m. hearing in the courtroom where a media camera was installed, the national media was present, and the law enforcement community was seated in the jury box directly behind the defense counsel table, at which time the court would read the prepared statement into the record and then disqualify both attorney Rozzi and attorney Baldwin in the presence of defendant Allen, his family, and the general public. After waiting approximately 1/2 of an hour for defendant Allen to arrive at the courthouse, attorney Rozzi and attorney Baldwin communicated with defendant Allen regarding the stark choice the court had offered in chambers. Defendant Allen reaffirmed his desire to move forward under the representation of attorney Rozzi and attorney Baldwin. As of October 24th, defendant Allen objects to the court's attempts to strip him of his current counsel, attorneys Rozzi and Baldwin. After speaking with Mr. Allen, attorney Rozzi and attorney Baldwin then returned to chambers, at which time attorney Rozzi articulated to the court that the court had engaged in an ambush of defense counsel entirely void of due process, and that attorney Rozzi would withdraw his appearance, but that said withdrawal was not a voluntary withdrawal because the court made clear that if attorney Rozzi did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by disqualifying him. All of the events in chambers occurred without any formal allegations of contemptuous behavior by attorneys Rozzi or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. In total, attorneys Rozzi and attorney Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantiated finding of a disciplinary action against either. At no time while in chambers did the court ever articulate to either attorney Rozzi or attorney Baldwin that their conduct compromised defendant Allen's defense in any way. In fact, defendant Allen himself doesn't believe this to be the case. There are no bona fide facts or circumstances wherein attorney Rozzi engaged in gross negligence, nor was there any showing that any conduct by attorney Rozzi resulted in negative consequences to another party, i.e., defendant Allen. In sum, attorneys Rozzi and Baldwin did nothing to compromise Richard M. Allen's defense. Attorney Rozzi's oral acquiescence to withdraw his appearance as defendant Allen's attorney was forced, coerced, and driven only by the circumstances created by the tribunal, which delivered 2 terrible options: quit or be shamed in public before being disqualified from representing Mr. Allen. The court's premeditated ambush of the defense placed attorneys Rozzi, Baldwin, and the client Richard Allen in a most compromising position. The trial court's stated intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. The jury trial in this matter is set to commence on January 8th of 2024, a full 1 year and 3 months after the arrest of Defendant Allen. The appointment of successor attorneys will prejudice Defendant Allen by and through further delays in his case and trial. If, however, Attorney Rozzi moves forward with his representation of Defendant Allen, there will be no need for 2 newly appointed attorneys to dedicate hundreds and thousands of hours toward a mere review of the discovery, which continues to pour in as recent as late September. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in a shifting of the strategy and approach of Allen's current defense team, which in turn would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rozzi to become familiar with the subject matter in a much more efficient and fiscally responsible way. All these truths weigh in favor of Richard Allen's choice to maintain Attorney Rozzi as his counsel of record. There are no circumstances under Rule 116 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rozzi's representation of Defendant Allen. Attorney Rozzi notices up this court of his intention to move forward with the representation of Defendant Allen until a final disposition of this matter. And there you can see he's made big signatures. So he wants to continue to defend his client Richard Allen, which to me means he's also pretty confident in his strategy and findings based on what he's seen in the discovery. Now we look at the second document. This one is 8 pages long, and then after that they're 2 pages, 1 pages, and so forth. So this is the biggest one of the lot. Motion to disqualify. Comes now the accused by counsel and pursuant to Rule 211 of the Indiana Code of Judicial Conduct and Rules 12b and d of the Indiana Rules of Criminal Procedure respectfully and moves for recusal of and change of judge from Judge Francis C. Gull. Yes, not only is Attorney Rozzi saying, I'm staying on the defense team, but also that judge needs to be recused. Oh my goodness, wow. Rule 211 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. The comments to Rule 211 provide additional guidance. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. Remember that the original judge, Benjamin Diener, recused himself shortly after Richard Allen was arrested. And there's many speculations as to why. I know the prosecutor's got a very important role, but there is some rumor out there that he is controlling this judge. I'm going to say it like that. Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court's administrative rules. Those pleadings include Frank's motion, filed on 9/18/23, Frank's memorandum, filed on 9/18/23, 3 affidavits, and then they give examples there, filed 10/10/23, and the affidavit of the leaker, Mitch Westerman. So now they're naming the leaker the crime scene photo leaker, the former associate friend of Andrew Baldwin. Okay, Judge Gull has not removed or hidden any state filings. And that's true. We've seen this happen a lot. There's a lot of things that the defense files that then gets released and made private, but not officially sealed. And then afterwards, maybe it is sealed. It's just been a little bit odd. Okay, they say Indiana Access to Court Records Rule 2A provides in pertinent part all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. And ACR Rule 4 provides that a court record is accessible to the public except as provided in Rule 5. ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secreted from the docket in this case apply to the above referenced documents, which have either disappeared from the CCS or are inaccessible to the public, nor were the documents filed using the procedures required by ACR Rule 5B, i.e. filing on green paper or filing electronically as a confidential document, along with an ACR form identifying the specific grounds upon which exclusion is based. By secreting pleadings from the docket without following the access to court records rules, Judge Gull has allowed violations of public access. I kind of agree with it. Let me know what you think. I don't know if you've done a bit of a deep dive yourself or tried to get the documents. It's been a little bit sus. Because those acts have only shielded documents from the defendant, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law, and 2.2, impartiality and fairness. On October 12, 2023, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed him by the state and federal constitutions. On October 19th of 2023, Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she'd ordered him transported and he was available. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused. This ignored clear precedent. On October 19, 2023, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case, or to voluntarily withdraw. Despite defense counsel requesting clarification as to the topics and motions to be addressed at the October 19, 2023 hearing, she gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. That same day, Judge Gull had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent in their representation of defendant Allen. Judge Gull's complaint was more about not having control over counsel rather than legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary of Judge Gull's complaints are as follows. A press release, generic in substance, was issued by the defense in November of 2022, before the court's gag order and only after repeated press conferences by the prosecution. Allen's response: the intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. I like that. I see the strategy. Level the playing field. And I do think it needs to be done in Delphi. 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not-so-coincidental and undisputed facts that individuals engaging in Norse paganistic practices may have not only murdered 2 girls, but that they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response: the court had previously ordered the accused transferred to a state prison at the request of the Carroll County Sheriff. His mental and physical health began an immediate decline. Prison guards in his area had Odinist emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defense had video of the patches, and the guards admitted that they wore them, which they did. If you didn't see that and you still think it's make-believe, they did. There were affidavits where they admitted, okay, we wore the patches. The defense had previously noted a connection between the murders and Odinism. The patches have since been removed. Mr. Rozzi cited instances of abuse. Those filings were within the obligation established guidelines imposed for effective representation. Mr. Baldwin had drafted an email to co-counsel but sent it to the wrong person due to self-populating in electronic mail. Allen's response: this was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rozzi, and the unintended recipient share the same first 3 letters of their first names. The email attachment contained no substantive information, just a bare-bones outline of a tiny portion of the discovery received by the defense in this case. The court alleged that Mr. Baldwin put improper statements in his Frank's memorandum, not false or misleading statements, just improper in her opinion. Allen's response: the court had disdain for the defense for not filing it under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. It again was required by applicable guidelines. That Mr. Rozzi had filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Allen's response: the filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which was often dysfunctional, to communicate with the outside world. Allen had no ability to speak with his wife in private as his phone calls were all being recorded. Allen's own attorneys were required to make advance reservations to visit him at the prison. It is entirely impractical that Allen would have had the means to prepare his own tort claim notice and or secure private counsel to do so. Mr. Baldwin had hired a lawyer to represent him in this matter. Allen's response: this is or was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related suicide. As a friend and colleague, David R. Hennessy suggested that he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualification. The true facts in a criminal case are often volatile. There was no untruth. The dissemination leak of crime scene photographs, in which neither Attorney Rozzi or Attorney Baldwin had knowledge of or participated in. Allen's response: see affidavit of Mitch Westerman previously filed. Guideline 1.1 of the Indiana Public Defenders Council Performance Guidelines for Criminal Defense Representation states, the paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defender Association, the National Advisory Commission on Criminal Justice Standards, and Goals and Rule 11 IRPC. Everything cited by Judge Gull as concerning was either not attributable to Attorney Rozzi or excellent and ethical lawyering in the best interests of the client's defense and mental and physical well-being. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gull showed no concern and did nothing. The court has routinely expressed umbrage at defense counsel's representations through investigations and filings, while silently abiding the prosecution's discovery delays and false statements by them or their agents. On October 19th of 2023, Judge Gull coerced an oral request to withdraw from Attorney Rozzi that did not comply with Rule 3.8H, Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in this cause. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. Throughout these proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. Counsel for the defendant are appointed pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail the representation of counsel. it has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It has also done so of its own accord without any precipitating motion or request. No due process has been afforded. Rule 211 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Rule 1.2 of the Indiana Code of Judicial Conduct states, "A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety." As previously stated, Judge Gull strong-armed attorneys Rozzi and Baldwin with a prepared statement that she intended to read into the record had either attorney resisted her efforts to remove them from the defense. Within minutes, Judge Gull took the bench, started the record, and informed those present and the viewing public that there existed an unexpected turn of events.
We've had an unexpected turn of events, ladies and gentlemen,
with the defense team withdrawing from the case. Judge Gull further stated that these circumstances were clearly outside of our control. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunal's lack of integrity and impartiality toward the public and usurp defendant Allen's right to competent legal representation. Rule 2.2 of the Indiana Code of Judicial Conduct requires that a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, "To ensure impartiality and fairness to all parties, a judge must be objective and open-minded." Rule 215 of the Indiana Code of Judicial Conduct in pertinent part states, "A judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority." It does not indicate that any such opinion of the court allows removal of appointed counsel without due process and against the wishes of the accused. Judge Gull has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 211 of the Indiana Code of Judicial Conduct, signed by Bradley A. Rozzi. And then there's more. State of Indiana versus Richard M. Allen. Praecipe for transcript. Comes now the defendant, Richard M. Allen, by counsel Bradley A. Rozzi, and files his praecipe for transcript in the above captioned matter. I hope I'm saying that right. Said transcript shall be of the in-chamber two-part hearing held on October 19th, 2023, in front of the Honorable Francis S. Gull, I think it's C. Gull, including the original recording and transcript thereof, dated this 25th day of October 2023. Yes, let's see the transcripts to know what really happened in there. Now here's a motion for continuance, which says, "Comes now the defendant, Richard M. Allen, by counsel Bradley A. Rozzi, and respectfully requests that this court continue the October 31st, 2023 hearing set in this cause. In support of said motion, defendant Allen states as follows. Counsel for defendant Allen is unable to locate any specific order wherein the court scheduled the initial October 31st, 2023 hearing date, nor is there any order which articulates exactly what matters were to be addressed, and how much time was to be set aside to address said matters. However, counsel does acknowledge that there have been discussions between the court and lawyers regarding the October 31st, 2023 hearing date and the possibility of the court conducting a hearing on the pending suppression motions filed by defendant Allen. On September 18th, 2023, defendant Allen filed his motion for Frank's hearing. The court is yet to issue a ruling on said motion. On October 2nd of 2023, defendant Allen filed his supplemental motion for a Frank's hearing. The court is yet to issue a ruling on said supplemental motion. I like how they're reminding them, just because you want to get rid of us now, what about all those things? Because it's true. What about all that? Does that just get thrown out too now? On October 3rd of 2023, defendant Allen filed an additional Frank's notice. The court has yet to issue a ruling on the issues raised in said notice. On or about October 14th, 2023, this court ordered defendant Allen's defense team to cease all work on defendant Allen's behalf and therein prohibited counsel from engaging in preparation for the October 31st, 2023 suppression hearing or any other matters associated with this case. On October 19th, 2023, the court engaged in actions which resulted in the court ordering the oral withdrawal of Attorney Baldwin from this cause. Attorney Rozzi remains the only active attorney of record in this cause. On or about October 25th, 2023, Attorney Rozzi filed a motion to disqualify. Attorney Rozzi believes that a full and final disposition on the motion to disqualify should take precedent over the issuance of any rulings on the Franks motions, the disposition of the pending suppression matters, and any other matters of substance which are currently before the court. Further, Defendant Allen believes that any suppression hearing in this cause will require more than 1 day of the court's time and will require the appearance of the witness, which most certainly cannot be secured between now and October 31st, 2023. And it is for these reasons that Defendant Allen requests that the hearing on October 31st, 2023 be continued to a date and time following a full and final disposition of the motion to disqualify, filed on October 25th, 2023, and for all other just and proper relief in the premises. And then, after all that, Judge Gull released this document, Order or Judgment of the Court. The court notes the following pleadings which may be resolved without further argument or hearing. The defendant's motion for broadcasting order is overbroad. The court will consider broadcast requests by the media after notice to the defense and state on a hearing-by-hearing basis. Therefore, the motion for broadcasting order is denied. The defendant's motion to quash subpoenas requested by the state for the defendant's medical and mental health records is granted as the state is not entitled to such records. The defendant's verified motion for immediate transfer of custody is denied based upon the state's response and attached affidavits. So Richard Allen is staying where he is. The defense's multiple motions for a Franks hearing remain unresolved as the court is still reviewing the thousands of pages of exhibits attached to the motions, as well as the multiple hours of digital evidence submitted by counsel. The court will continue to review same. Defendant's motion to suppress and supplemental motions to suppress, as well as the state's response, will be set for hearing upon resolution of the defense Franks motions. Prior to the scheduled hearing this date, attorneys Rozzi and Baldwin advised the court that they will be withdrawing their representation of the defendant. The court accepts their representations and orders them withdrawn from the cause. It feels like because I said so, a little bit. What do you think? Counsel ordered to comply with a previously entered protective order on discovery and are ordered to turn the discovery over in full to the state of Indiana to be made available to successor counsel. The court requests their cooperation with successor counsel in the best interests of their former client, but is not requiring them to cooperate. The court will maintain the hearing scheduled for October 31st, 2023 at 9 a.m. in the Carroll Circuit Court. So not the Allen Superior Court, it will be back in the Carroll Circuit Court for successor counsel to appear. Clerk of Carroll Circuit Court ordered to remove attorneys Baldwin and Rozzi as attorneys of record in this cause. Let me know what you think in the comments below. You know, to me, it just feels like, look, man, I already said it. You're off the case. Okay, so court clerk, can you please just remove their names? Thank you. Yeah, we're continuing for October 31st, but you're not invited. That's what it seems like, right? Which doesn't seem like normal legal proceedings. I don't know. It just doesn't come across that professional, in my opinion. Maybe I'm wrong. Let me know. There's a lot of Grizzlies here with lots of legal experience. Love to read your comments. Leave them below. If you haven't yet subscribed, do it because it lights up now like confetti. It's a new feature on YouTube, right? So if you subscribe, hit it again, set the notifications to all. You'll get all notifications for when I next upload a video or go live. There's always a lot going on. I'm always making a lot of things for you. I hope that you enjoyed this episode. There's a lot to think about here. Can't wait for the October 31st hearing to see, well, what happens? What happens here? And have they already found new counsel or, I don't know. It's all just very hectic. So I'll be keeping a close eye on this case and let you know if there's any other updates. I mean, October 31st is around the corner. So let's see what happens there. I wonder what that's going to be like. Will Bradley Rozzi, you know, even if he gets thrown off the case, is he going to appear there as a public person? He can be there, right? Ooh, it's going to be so interesting. Oh my goodness. So if you like the way that I present true crime, please like the video and share it. You can use hashtags Abby and Libby or Libby and Abby or Justice for Abby and Libby or hashtag Delphi or Grizzly True Crime. All of those. A combination of all would be great. I will see you in the next one. Thank you so much and stay safe.